Hi guys, it's Kathy. I hope you're doing well. And you should be, because it was an excellent day with McNally a bit ago. So we're going to the prelim, June 30th, 1994, second part. So before we were talking, the defense wanted to give up one hair from O.J. Simpson, one. Um, and the prosecutor was like, no, that won't work. We need 100. So the judge said, okay, he can have 10. And the prosecutor said, no, 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 wait, we got to present our evidence in a hearing. So they have the leader. I don't know what her title is, the chief or whatever of the New York forensics department, police forensics department or whatever. And she's still explaining about hair follicles. They're also talking about blood. They got blood from different items. And the defense team wants it because they want their own experts to test this blood. Um, but the prosecutor is like, well, no, we need it. So the forensics lady, I can't remember her title, is explaining which items they can have blood from, which items they cannot have blood from, and which items we just don't know if they can have blood from yet until they run their tests and see if there's anything left over. Um, so that's where we're at. That's what we happened yesterday. I don't know if we listened yesterday, but that's really what happened. And we're going to continue on that today. So here we go.
All right, we're once again on the record, a case of People versus Simpson. The defendant is present with counsel. The people are represented. Mr. Shapiro, I assume that you do now have a copy of the curriculum vitae?
Your Honor, what I have is not the curriculum vitae, but a statement of qualifications.
All right. That's all we have. And Ms. Kessler, if you retake the witness stand. You've previously been sworn and remain under oath.
Yes, Your Honor.
Mr. Shapiro.
Good morning.
Morning.
Is it Miss or Mrs. Kessler?
Mrs. or
And-
Ms., whichever you prefer.
What do you prefer?
Doesn't matter.
Ms. Kessler, does your husband work for Los Angeles Police Department as a detective?
Yes, he does.
I think it goes to credibility. I can make an offer.
It
of
might
proof
not
if you'd
end.
like.
The objection is sustained. The motion to strike is granted.
Your Honor, may I inquire as to whether or not he is or has been assigned to the very division that's investigating this case? Would that be of relevance to the court?
You can ask that.
Thank you. What is
Overruled.
Has your husband been assigned to the robbery homicide division, to your knowledge?
Yes, he has.
Is he still assigned?
Yes, he is.
And do you personally know the two lead detectives in this case?
I've worked with them for several years.
Do you know them personally outside of work?
No,
Have you discussed this case with them?
just as pertains to the case and evidence involved in the case.
And have you discussed this case with your husband?
Not really, no.
You have provided us with a statement of qualifications consisting of 3 pages in the form really of check boxes. Is this what you consider your curriculum vitae?
This is the only thing that we have used most recent years since Prop 115. This is all I have available at this time. This is what we've been considering.
Our haircuts.
CV, yes.
My question is, do you consider this your curriculum vitae?
I have used this type of statement for years. I used to spell it out in terminology rather than have check boxes, and it used to look more narrative, but it didn't go into much greater detail.
Prior to being employed by the Los Angeles Police Department, what was your work experience?
I worked for approximately 5 years in a private laboratory performing chemical analysis and biological analyses.
What part of that work consisted of DNA?
The DNA wasn't being done until the last few years.
What part of that work concerned microscopic comparison of hair?
None then.
What part of that work consisted of serology?
None at that time, other than in my master's thesis.
What part of that work consisted of maintaining samples of blood?
None.
What part of that work consisted of collecting samples of blood?
None.
What part of that work consisted of preserving samples of blood?
None.
Now, you have authored one article, is that correct?
I authored one article, yes. I've been co-author on several others that aren't listed here.
And what is the article that you have authored?
Don't run.
It was, I have to read the actual title. The lab goes to the lab,
When was that published?
1982,
And you were the co-author on that.
yes.
Have you authored any articles?
No,
What did that article deal with?
that is about clandestine laboratories,
Drug cases?
yes.
Had nothing to do with serology?
No,
Have you published or co-authored any articles on serology?
no,
Have you published or co-authored any articles on hair analysis?
no.
You indicate your training.
I also don't know any of the facts other than the glove. And we just all thought back then that he got off because he was a celebrity. That was it. I mean, there was no, was he guilty? Was he innocent? No, he's a celebrity, so he's fine. He can go.
In the discipline of hair. Is that how you refer to it, the discipline of hair?
Actually, it's hair is just like a fiber, so I guess it'd be hair and fiber analysis.
Let me refer you to page 3 of your statement of qualifications,
Mhm.
Mrs. Kessler. You list their courtroom experience, discipline, hair, 1980 through 1986. Is that correct?
That's correct. That's the last time I testified on a hair case.
And up until that point in time, you testified approximately 35 times?
Mm-hmm. That's correct.
I don't see anything on your statement of qualifications indicating testifying regarding blood samples or blood preservation. Is your qualification statement incomplete in that regard?
No, it's under crime scene investigation and preservation of evidence on page 2. I've testified approximately 55 times in crime scene investigation and preservation of evidence. And in each of those cases, or almost all of those, has to do with blood preservation and obtaining sufficient sample for analysis purposes.
When was the last time you testified in a court of law regarding the amount of a sample necessary for preservation for later analysis?
Oh, let's see, probably about when did I prepare this? Actually, the date changes automatically. So the last time I testified, and that was probably about 1988, 86.
Do you recall which it was, 88 or 86?
No, I don't recall. I really don't
I
recall
don't
the year.
know
So
if I believe
sometime
that.
between 1982 and now, but only once or twice since then, because I've been in management most of that time.
And how many times have you testified since 1976 regarding the amount of blood that is necessary to preserve a sample for later analysis?
Between 30 and 55 times. Almost all those cases listed on page 2 that refer to crime scene investigation and preservation of evidence are dealing with blood.
And you were specifically asked the amount of blood necessary to be preserved for later analysis? Is that your testimony?
I'm not sure if that was exactly what was questioned, no.
In fact, that was never asked of you before today. Isn't that the case?
No, that's not true.
Hi,
Do you
Adam.
recall when the last time you testified to the amount of blood necessary for
We're going to know the truth. We're about to see the whole trial. The truth shall come to us.
Splitting was?
I don't believe I've ever been asked to testify to that.
Now, I notice in your statement of qualifications that you indeed attended a seminar on DNA.
That's true.
Is that correct?
Yes,
And that was in January of 1988?
that was one, yes.
And
I
that's
hope you
8
get a
hours?
cut.
That's one, yes. I attended several which are not on here. As I said, I was not prepared for this, so this is not up to date.
Well, it's dated the 24th, is it not,
I was
of
just-
this month?
As I explained, the computer automatically updates it, and I did not have time to go back in. There was apparently a rush to get this here, so.
Isn't that something that's standard for people who testify as expert witnesses to have a curriculum vitae that is current to date?
It's only required if I'm going to bring it to court, and as I stated, I don't testify much anymore, so I don't update this on a routine basis now. I keep track of my interests and what I'm doing, but I don't update the CV all the time.
When were you notified that you were going to come to court as a witness in this case?
Yesterday, or perhaps the day before, late at night.
When were you given
You're
information
never
regarding
gonna
this
find your
case?
body.
When were you given evidence regarding this case?
Well, I was never given evidence.
When were you aware that evidence was available during this case?
When the case,
She rolled her eyes the exact same time I rolled my eyes. Ah.
Oh, you can have to go.
whenever the case went down, there was evidence, but again, I did not expect to be involved.
You didn't consider yourself as a potential witness in this case?
No, I did not.
Well, the things that you haven't had time to add on to your statement of qualifications, let's talk about DNA. What additional qualifications do you have since 8 hours of a seminar in 1988?
I have spent many, many hours with experts in the field from private laboratories, including Cellmark, Life Codes. I have attended all the American Academy meetings for the past, since 1985, which is once a year for 40 hours a week. And I would say at least 2 days of that is always devoted to DNA. I also have attended all the ASCLD board of directors meetings once a year, twice a year for the last, since 1985 also. And there's always an update by the FBI and private laboratories on DNA analysis and what is required for that. And I have been instrumental in implementation of DNA in our laboratory as the manager, and so I'm very familiar with it.
Do you know who the scientist is that is responsible for the DNA subtypes that are being used in this case?
The scientist that's
Yes.
responsible, the person that developed it
Yes.
individually?
Yes.
No, not off the top of my head. I have to look that up.
I take it you haven't read any of the books that he's published on this subject.
No, I have not read extensive books on the subject.
And I take it that you haven't taken any courses that directly relate to DNA in a school atmosphere.
Except in college, and DNA was, barely mentioned as part of genetics and microbiology.
And when was that? I don't want to have to set a
That's
specific
quite all
date.
right, counsel. I'm not concerned about my age here. It was probably 1970.
And that was the last time you were involved in any academic setting.
Academic setting, that's correct.
Now, I understand that you list as your training the following things. How to turn your work group into a winning team, Los Angeles Police Department.
That's management training.
Okay, that has nothing to do with winning or losing a criminal case.
Not that I recall.
And then you've had 2 courses in management seminar.
Actually, that's an ongoing management seminar, as I stated earlier. As a member of the American Society of Crime Laboratory Directors Board of Directors, I attend management seminars at the FBI twice a year.
And you attend seminars regarding sexual harassment.
I've attended, there's always an update on that, believe me.
And you've gone to forensic alcohol supervisor school?
Nicole's mother.
That's correct.
Do you consider yourself an expert in DNA?
Not in DNA. I consider myself an expert in preservation, collection, and evaluation of evidence for all types of tests.
Do you consider yourself an expert in serology?
Not in today's current serology. Again, evaluation, and I understand it. I can review reports and I can review people's analysis. I would never try to do it at the bench, but I do understand it.
Do you consider yourself an expert in the comparison of hair?
Yes, I do.
And what scientific training have you had academically regarding the comparison of hair?
Well, there isn't really any academic training other than my master's program, in which part of the courses in criminalistics involve comparison of hair. And also the Macron School, Hairs and Fibers, that's one of the academic courses, and I've been trained on the job training in the FBI method of hairs and fibers analysis.
Are you familiar with a gentleman by the name of Dr. Henry Lee?
Yes, I am.
Can you tell us who he is?
He is a forensic scientist out of Connecticut.
Do you have an opinion regarding his qualifications in this field?
Not in hair examination, I have no idea.
What about as a forensic scientist?
I don't know if Henry actually does any bench work anymore, if he's like myself and he advises and oversees.
There are some celebrities that we know of today in that courtroom. I just don't know who they are. So if you see anybody, shout it out.
And reviews work and evaluates evidence. Other than that, I know he's like myself. He used to do a lot of bench work, and I considered at that time what he was doing as well as what I was doing, him to be an expert. He is also a member of all the associations that I'm a member of.
Is he a member of any organizations that you're not a member of?
I don't know.
Have you seen his 50-page curriculum vitae recently?
Objection, Your Honor. Counsel's testifying as hearsay. You have no evidence of that. If counsel wants to put it into evidence and call Dr. Lee, that'd be fine, but.
The objection is sustained.
If Dr. Lee is of the opinion that you only need one hair for DNA testing, would you agree or disagree with that? Yes or no?
Objection irrelevant.
Sustained.
I'd like to now, Your Honor, direct the court's attention and the prosecutor's attention to the list of evidence, and I would like to painstakingly, as it may be, go through each item to see what tests were done, what tests are anticipated, and what the amount of sample is and how much remains.
Objection irrelevant.
I don't think it's irrelevant. However, do you have that information at your fingertips?
I'm sorry, could you repeat what you?
You testified there are 60 items of evidence. I'd like to first direct your attention to the items of evidence that relate to blood. And I would like to review with you each one of those items of evidence. What tests have been performed at your laboratory to date? And what tests you anticipate performing in the future, so the judge can make a determination as to whether or not we will be able to perform the exact same test. What we would like, Your Honor, is this. If they have done serology and DNA, and there still remains a sample, we would like to do serology and DNA.
No, I think I understand where you're going with this. You want to know how much of a sample remains
Exactly.
and what tests have been done. And if no tests have been done, you want to know that also.
Correct.
Okay.
Your Honor, I think that perhaps it would be a lot more efficient if counsel would simply look at the documents he was given today, which indicate exactly what tests have been done and not done. And with respect to having the court determine whether or not further testing should be done, or whether sufficient volume exists to provide a split at this point in time as to any future evidence, how could the court do that? That's a matter for expert opinion.
Well, that's correct. And my understanding is the defense apparently intends to present some expert testimony on that issue.
This is not the trial. This is the preliminary hearing. So, I mean, she could be a judge, but she also could be a magistrate. I don't know.
Well, that was not my understanding, and I expressly asked Mr. Yeoman last night when he called to ask me what the order of witnesses would be. I asked him what witnesses he intended to call today, and he informed me there were none.
Mr. Shapiro?
Your Honor, I think we will be able to satisfy the court from this witness through our cross-examination that the tests that have been done, samples remain, and those samples will be enough for us to duplicate those tests in almost every area.
All right, well,
In other words, counsel is indicating that he is not going to call any witnesses, expert or otherwise, pertaining to this blood split issue.
that seems to be the general import of what you're saying. Is that correct?
Your Honor, that is a general import. Obviously, we have the right to call witnesses. We do not anticipate calling witnesses, but as the court well knows, depending on the answers that are given, we will make that determination at an appropriate time.
All right.
Counsel is in possession of the information he is seeking in the list that was provided to him this morning. It indicates what tests have been performed. If counsel needs to inquire further as to what tests are planned, that could be done collectively as opposed to item by item.
Well, I'm not going to tell counsel that he has to examine in a collective fashion. You can go item by item. If you have this particular information, it might be helpful if the witness has it also to refer to it because there's so many items by number. I don't want to get into the results, however, of any of these tests.
I will not ask the results, and that is not my intention, Your Honor.
All right. You may
Thank
proceed.
you. May I direct your attention to item number 1? And just let me know when you have an opportunity to focus on that.
I'm fine.
Item number 1 contains 2 bindles,
No, it contains 2 swatches.
2 swatches. Okay,
I'm sorry, item 1 is 1 bindle containing 2 swatches, and item 1C is a swatch, which is just a control sample.
So you would say that item number 1 has 2 bindles that are composed of a swatch and a control.
No, I'd prefer to keep them separate because it'll just be confusing if we could stick to item 1 and then 1C separately. Item 1 contains 2 swatches.
You brought it up.
And was any analysis done on item 1?
Not yet.
How much evidence is contained in item 1?
There is 1 swatch that's approximately 2 millimeters square and 1 swatch which is 1 millimeter square.
Where was that found?
Oh, yeah. I'm sorry, I thought we were going to deal with just quantity of evidence, not location.
Mr. Your Honor, counsel is in possession of a property report that indicates where all of these items were found.
I don't think it's necessary at this
Very
point in
well.
time to know where that
Thank
was
you.
located.
Thank you. When do you anticipate analyzing that?
Objection irrelevant. Counsel wants to know at this
Very much.
point what this witness's opinion is with respect to the availability of a blood split. When the test will be performed in the future is irrelevant to that determination. I think that counsel should be confining his questioning to matters that are now at issue. And that would be what tests have been performed, what tests are planned, and what volume she anticipates will be available for the blood split, if any.
I don't think that there's a problem asking about when a test is going to be performed because that, I suppose, would be relevant in terms of knowing when there would be sufficient samples, since the witness has indicated that apparently she won't know until the tests are actually performed on any of these items.
Bill, OJ. Bill, OJ. Now, I know some of you are wondering if they were the same person, but look, we see them both in the same room right now together. So you can put those rumors aside. Bill is not OJ Simpson and never has been. So, hi, Bill.
Whether there's going to be enough for a split. And we'll just be back here again doing this in the future to try to find out this information. If she knows when a test is scheduled at this point, she can tell us. If she doesn't know, then that's fine.
My point is, Your Honor, it doesn't matter because with respect to all of the items, the few items that she's indicated may be capable of providing a split, she won't have the answer for that either until the testing is done. So we're going to be back here anyway. Because one way or
Well, I
another,
understand that. If within her knowledge, at her fingertips, here on the witness stand, she happens to know when a particular test is scheduled and fine, she can answer that. If she doesn't, we're not going to go and research it anywhere. right, Mr. Shapiro.
asked to
Yes, you may
be-
answer the question. if
We
you
have not
recall.
had a chance to get back to this at this time and schedule the testing. We spent a lot of time evaluating the samples. That's about all we've had time to do.
When do you anticipate testing it?
Probably within the next, they'll be either sent out or be done in our laboratory within the next, as soon as it can be arranged, probably. It depends on our schedule. We have other courts, and so I'd say within the next 3-4 weeks.
What is the criteria for sending it out?
It depends on whether we believe that we can do it in-house. It depends what we're going to do on it. Obviously, if it's RFLP that we think can be done, it's going to have to be sent out. We don't do that in-house.
Is that the only thing that you would send it out for?
No, not necessarily. We also, if we're going to send it for RFLP, it's a good chance that we may decide to send all of it out for PCR, and that determination hasn't been made yet. Conventional serology, if it's possible, would be done in-house.
What test do you anticipate doing on this sample?
On this sample, it appears that, based on the small size, that we would be best suited to just attempt PCR and possibly limited conventional. But we'll try as much as possible. It doesn't appear to be enough for RFLP.
Limited conventional refers to what?
Limited means we will pick the best markers out of conventional serology, whatever they may be, the most discriminating markers, and just do those. We probably cannot do a full battery of conventional serology tests.
After the serology test is done, how much of that sample will be consumed?
Probably most of it will be consumed. It'll be extracted. The extract will still remain, but the sample as is, the cost squares will be consumed.
Part of the sample will remain, however.
The extract, which means someone has already worked on it and developed an extract.
Will any of the original sample be maintained?
No, can't.
So after serology, you are left with just an extract.
That's correct.
How much of the extract will be
I
left?
have no idea.
What do you anticipate based on the
It's not
size?
a volume at that point, because it depends on the concentration of the sample, and you can concentrate that down into essentially nil. So it's a concentration more than it is a volume. The volume is sort of irrelevant. It's more concentration of sample than volume. I can dilute it up and give you a gallon of extract, which means nothing,
Would there,
because it'd be so dilute you couldn't use it.
in your opinion, is there enough material here for both your laboratory to do a serology and for a sample to be given to independent laboratory for serology?
No,
So your opinion is there will be none left for any PCR test?
that's not what I said. I said there wouldn't be enough for us to do our work and someone else to take original sample from scratch and do any kind of serology testing.
So, you know how I said there were over 400 videos? That was my nice way of saying 498.
Whether it's PCR, ABO, RFLP, et cetera.
Let me ask you regarding this PCR, that's a DNA test, is that
Yes, it
correct?
is.
And are there false positives in that?
Objection irrelevant.
Sustained. I don't want to get into the efficacy of various tests at this point.
Thank
Your
you.
Honor, may I
Let's-
make a report? This is going to take hours in the manner in which counsel is proceeding. And I don't know that evidence is required to be taken in this manner. Counsel could sit down with his expert and talk to this expert, who would be delighted to share all of her findings with counsel and any expert counsel chooses to have with him, so that he can understand what her position is. And then we could frame a stipulation as to the nature of her testimony. This is going to take all day in the manner in which counsel is proceeding. And I don't think it's going to assist the court any in being able to determine its ruling.
Your Honor, with all due respect, I am representing a man who is charged with 2 counts of first-degree murder, where the people may be asking for the death penalty. And if it takes 2 hours to determine whether or not there'll be enough of a sample for an independent evaluation, where we believe samples can be contaminated, where false positives are possible, and where errors can take place in laboratory procedure, I don't think that's being excessive at all.
Your Honor, I take exception to the manner in which counsel has characterized my response. I am making a suggestion to counsel that would allow him to have much more information that he's going to obtain in the manner in which he's proceeding. If he wants the information so that he can make a determination as to how he wants to proceed with the evidence and what he wants to argue to the court, what I am suggesting
would allow him to learn far more than he will in this manner. He needs an expert at his side so that he can understand what this witness is telling him, and the manner in which he's proceeding will not permit him to do so. So I am actually offering him the opportunity to learn a great deal more than he is at the current time. I'm trying to assist counsel in being more efficient and more effective.
We certainly appreciate that.
Mr. Shapiro, you know, I'm going to allow you to
It will not be
present
that-
your motion your way.
Thank you.
Um,
It's not going to be that time consuming. We've been here since 9:30 and so far I've been allowed to ask one question.
Well, I
on
think
this-
you've
on
asked a
this
few
evi-
more.
Well, but on the direct evidence, there's 60 items, about 30 are blood, and I think the responses should take less than a minute. So if we don't have any further interruptions or suggestions as to how we should present our case, perhaps we can finish this.
Excuse me.
I don't think, excuse me, I don't think that's necessary from either one of you. So let's just proceed.
Thank you. The next item of blood that you have listed is item
This is not the trial yet. It's just the preliminary hearing.
number 4. Is that correct?
Hey, Jen.
Well, if you're referring to simply swatches containing red stains that appear to be blood, or that tested preliminary positive for blood, yes.
That's what we're referring to.
Okay, number 4.
That's item number 4. Would you describe item number 4, please?
It's one swatch that is 8 millimeters square. Approximately square. This is all an approximation on these measurements.
Have any tests been conducted on that today?
No.
Do you anticipate any tests being conducted?
Yes.
When do you anticipate tests being conducted?
My answer on the testing would all be the same. If overall, maybe that would help. If
No,
we
I'd like to limit it just to this item
Okay.
because this has a different quantity than the first, does it not?
Well, yes, but your battery of tests proceed in the same manner. And the extract on all of them has to be done first. And it's the same extract that's used for both PCR and RFP. So
If you have no strenuous objection, if you could address item number 4 as a separate item, I think
Okay.
that would be helpful for us.
that's fine. I'm just trying to make it less confusing for everyone.
Thank you.
Ask away. Ask
Could you
away.
repeat where we are?
Do you recall the question?
No, I do not.
Regarding item number 4, do you anticipate doing blood tests on this?
Yes.
What blood tests do you anticipate doing?
It appears to be enough to do,
Change my mind.
we hopefully to do both PCR, some conventional serology, and possibly RFLP, which would consume the sample.
If you just did serology, would there be enough of a sample left for an independent laboratory to conduct a serology test?
Well, serology, to me, includes DNA. So serology, DNA, part of all of it. Are you talking about conventional serology?
Let's get our terms correctly. Conventional serology is blood typing, is that correct?
Conventional serology is genetic markers, as is DNA, if you will. They're all genetic markers.
Let's start with the first test that you would anticipate doing and use your terms as to what test that would be.
I'm assuming, what I think we would do here first would be to attempt to do DNA, and then if there's any remaining, do conventional serology.
If you did DNA first, do you anticipate, is there enough to do DNA?
I indicated that RFLP, which is the most sample consuming DNA,
Thank you.
post PCR, which requires less sample, that we would consume the sample.
You haven't done RFLP on anything yet, have you?
No,
All right, so let's go with what you've done so far. So far, you've done serology on samples and you've done PCR on samples, is that correct?
that's correct.
Do you anticipate doing serology on this sample? Yes or no?
Only if there's sufficient sample.
Do you know as an expert witness whether or not the quantity you have is a sufficient sample for serology? Yes or no?
As I indicated before, if we only did serology, yes, there's probably enough there to do only serology, but we would want to do RFLP first.
Would you just please answer my questions?
I'm confused.
Argumentative. The witness is attempting to answer his question.
All right, ask your question again,
Thank
Mr.
you.
Shapiro.
Do you have enough of a sample to do standard serology? Yes or no?
It appears we do.
If you did standard serology, would there be enough of a sample remaining for an independent laboratory to do serology?
Objection irrelevant. Your Honor, this is the point. We intend to perform serology, RFLP, PCR, polymarkers, every test available on each piece of evidence. And the only relevant question is whether after the completion of all of those tests, there will be sufficient evidence left for a split.
All right, the objection is sustained.
May I be heard on that, Your Honor?
Yes.
Based on the records we have received, the following tests have been done.
Have
by-
already been done?
Have been done by LAPD, serology and a DNA test known as PCR. They have done no other test. And I've asked the witness this and she has acknowledged that. What I would like
My opinion is OJ believed it.
to establish for the record is this. For those that have not been done yet, just go piece by piece. If you do serology, would there be enough for us to do serology? If you do PCR, would there be enough for us to do PCR? If you do other tests, would there be enough for us to do it? To make a record, because if these samples are consumed and we want to contest the fact that possibly exculpatory evidence existed, that we were deprived the opportunity of exploring,
Casey.
that should be
Thank
part of the
you.
court record.
Your Honor, and it's irrelevant to our consideration. That is exactly the point. I don't think counsel understands. We have a battery of tests to which this evidence will be subjected. The question to be answered is whether or not after the tests are completed, they're sufficient for a split. That's the question, not whether after each test is completed, because counsel has no right to dictate to the prosecution the manner in which a case is investigated. We will subject the evidence to every test available.
Of course you didn't straighten that hair. That cost like $30. That cost like $30 in 3 hours to get that done like that.
And every test possible. And at the conclusion of those tests, if there is sufficient left for a split, we will be delighted to share it with counsel. We've made that clear. And this expert is only here to testify as to whether or not after the conclusion of all of the testing we deem appropriate, such amount will be left over. That's the only thing, not after each test. After each test makes no difference.
All right, Mr. Shapiro, I agree with the prosecution on this point because I'm not in a position, I'm not going to put myself in a position to say that they can or cannot perform a given test on a given sample. And I don't think that's what the court's position should be.
I want the record, just to be clear, that we are requesting samples of all material relating to blood that have not yet been tested for our own testing. And I will leave it at that.
Okay, and I think that record is clear.
Thank you very much,
Let
Your
me
Honor.
also make the record clear then, Your Honor, that I have repeatedly advised counsel that I am going to make every single test ready for observation to him and to his expert. Every test performed can be observed in every step of the process by his experts at his choice. And if there's some question he has or concern about buffers or solutions being contaminated, we will be delighted to provide a split of any buffer or solution that is being used in the conducting of any test. So counsel is going to be allowed to examine every piece of evidence, observe the testing process to make sure that evidence is appropriately handled. And I want to reiterate that invitation on the record once again.
All right, and I think the record is clear on that also.
Thank you very much, Your Honor. The next item that blood was found is item
We
number 5. Is that
are-
correct?
That's
Yes,
correct.
we are.
And would you, have you done tests on that item or not?
No,
Next item where blood was found is item number 6. Is that correct?
that's correct.
Have you done testing on that? The next item where blood was found is item number 9. Is that correct?
One seat on that.
No, I believe number 7.
Number 7? Okay. Have tests been done on that?
No.
What about number 8?
No.
Was blood found in both of those?
Yes.
What's the next item where blood was found?
Number 9.
Has testing been done on that?
Yes.
What test, what was the first test that was done on item number 9?
The first test, because the sample appears to be very weak, was PCR.
Is there anything remaining of that sample?
The glove gives quite a bit of positive area for blood. You cannot see it, you cannot differentiate how much is there because of the leather. And until we actually extract it and work with it, we don't know. Yes, there's some remaining, we don't know how much.
Is that enough remaining, in your opinion, for an independent laboratory to conduct their own investigation?
Not to split it this time, no.
Is there enough remaining for an independent laboratory to conduct their investigation, yes or no?
Objection asked and answered.
It was asked, but it wasn't answered.
Do you know?
Well, I have to clarify this. If you mean, we're not done testing. So do you mean at this time or when we're done testing?
At this time.
At this,
Objection irrelevant.
Sustained.
What additional tests do you intend to do on this?
we're going to do everything possible. And again, until it's extracted, I believe we'll even try for RFLP DNA, but we're skeptical that there'll be sufficient there.
Don't look, Fuzzy.
The next item I have, and correct me if I'm wrong, is item 17 where blood was found.
No, actually number 11.
11 and 12, you have not analyzed yet, is that correct?
No, I'm
Next,
sorry, 11 we did not test, 12 we did.
12 you did test.
Yeah, I didn't hear you say, I almost thought you didn't say 12 because I thought we were going one at a time.
And on 12, what test did you perform?
PCR,
Is there any sample left on that?
yes there is, and we're not completed with our analysis yet.
Will there be any sample left, in your opinion, when you complete your analysis?
Objection irrelevant.
Well, you're referring to completing all analysis. Is that correct, Mr. Shapiro? in your
Yes.
Question? Overruled. You can answer that.
I believe I answered this earlier. I felt that there would be a possible sufficient amount when we're done, but we won't know until we're done.
The next item where blood was found is item 17.
Actually, number 14,
There was an analysis done,
yes, PCR.
and the sample has been depleted.
Yes, it has. It was very small.
And you say an extract was saved.
Yes, we saved the extract.
What
We
does that
still have
mean?
that. That means the portion at which you're concerned about contamination, which is in the extraction process, or at least one of the processes involving DNA of PCR, we extract the sample. We still have what's left of the extract. You don't need all the extract.
Is
You
that a-
have to extract the whole sample.
Is a portion of that available for us?
We're not done. We may try to do some more with that, including polymarker. We'll send the extract.
Do you anticipate a sample will be left for us?
Probably not, because again, it's a very, very weak, small stain.
The next item where blood was recovered.
Well, 17 is the reference blood. That wasn't found there. That's a reference known blood.
Next where blood was found at the scene. At one of the crime scenes.
Well, item 20.
What about item 18? Shoes, was any
Oh,
blood
no,
found?
no, there wasn't any. That's the test. We did a search for blood, didn't find any. I don't even know if we're getting into that.
All right, the next item that you have,
20?
has that been tested yet?
No,
21,
not tested.
23,
Thank you, Jen,
22,
so much.
not tested.
Don't be peer pressured into doing
23.
that. Never, ever again.
23 PCR,
Never.
plus the extract remains, and we intend to do the same with that as all others.
you don't, right now, does a sample exist? For reanalysis of PCR?
There's a small amount plus the extract, yes.
24,
No, not tested.
next item,
25, we did PCR.
is there a sample left?
There's a very small amount of sample left about. Actually, this is a small amount of fibers with a small amount of stain, and that's like, kind of like the glove. It's difficult until we extract it to know how strong it is.
Would that be available to the defense?
We don't know until we send it out for polymarker and some of the others. The extract will always be available, whether it's sufficient for testing, I don't know.
Next item that you recovered
26?
regarding blood, that has not been tested yet?
No.
Next items,
28 are some threads. The sample's so small, it's not even what I consider a swatch. It's small, just 2 or 3 little cloth threads with thread stain on them. It has not been tested.
next item is 29,
Correct?
that has not been tested?
No,
Next item is 30,
Nothing.
it's not been tested.
Absolutely
31,
nothing. Go to bed.
PCR only, and the extract remains plus 1 small square, and we don't anticipate any of that being left except the extract.
At the present time, though, there remains sample.
That's correct. As you can see in the column, it indicates what's still there, and that's your 2 by 3 millimeter piece.
Next item.
Item 32,
Has that been tested yet?
no. And there are several little threads.
Next item is item 33, carpeting.
Item 33 has has blood in several very small areas of some pattern resembling possibly a shoe print. And so we're holding off on that till we can decide how to progress and develop and look at the shoe print as well as the blood without losing either one.
Well, of course,
We did do,
what tests have been done on that?
we did on a separate little stain of one thread, we did PCR.
Is the same size sample available for the defense?
It's threads all over the carpet. You know, it's a carpet with small little spatters of stain on it.
Nice. I bet that.
Would that be available to the defense?
Not at this time. I think it's very weak, and we haven't done the shoe print either.
Item 34, you have not analyzed yet?
And we did PCR.
You did.
Mhm,
And
That's correct.
is there anything left on that?
There's a 2 by 3 millimeter piece that we have yet to continue with.
Is that enough for the defense to use for independent analysis?
Well, I don't know because we're not finished. We're not finished on any of these, actually, except the one that was consumed. We probably can't do anything more on that, but we're going to attempt to anyway.
At the present time, does there remain enough for a sample for reanalysis?
Yes.
Thank you.
Objection, that's irrelevant.
Sustained.
Next item.
And may I just have a continuing objection to all of these questions concerning the request for whether there would be sufficient split after 1 or 2 tests before all the testing is completed. And counsel keeps going back to this, and I'm getting tired of objecting to the same thing. The court keeps sustaining it. He's asking the irrelevant issue, which is after each test, if there's going to be enough left. The question is, after all tests, is there enough left?
Ms. Clark, if you do have an objection, you're just going to have to make it question by question. Thank you.
Next item, please. With blood.
Number 37
That's a glove.
is a glove, and there appears to be stains on it that we have not tested yet, but they appear to be blood. And I'm sorry, they were preliminary tested positive for blood.
You know the size of that sample?
It's very small. There's a few drops,
What test do you anticipate?
as many as possible. Probably can't do RFLP, but we are going to certainly have it evaluated further.
When do you anticipate doing that?
We're going to begin early, probably Monday, determining who's going to do what testing.
Is there a standard laboratory that LAPD uses for independent testing?
No, there's not. Well, there's more than one we have. We use 2 or 3 labs for different types of testing.
For RFLP, who do you use?
We most often use Cellmark.
Next item where any blood material was found.
Number 41, I believe. We did PCR.
What was the size of that sample?
There's a there's several little swatches. There's 3 of them, but they're very weak.
Do you anticipate doing any more?
We're going to try to do polymarker, probably.
Next,
That's our hope, yes. We're going to attempt to do that.
next item.
Number 42, PCR has already been done.
Do you have the results of that?
Objection, irrelevant.
I don't think we've
Sustained.
gotten that yet. I just want to check. It was just for information only.
Okay.
Any sample remains?
All right, she's withdrawn her objection. Do you have the results on that PCR number 42?
I don't know if I have them here, but I do know that I gave them to the defense last week at that same meeting.
My notes don't have the accuracy of that result down. Any sample,
Sorry, Ron, I didn't understand.
we'll withdraw the question. Any sample remain of that?
Yes, that's one of the ones that we're hopeful after testing, after we complete our testing, that there may be some available for the defense, but we're not sure.
Next item.
Number 44. Oh, I'm sorry, I'm starting to skip to what we already did. I'm losing track in this melee of samples here. Number 43, there are 4 swatches. And although there's 4, they're weak in color. And we anticipate that the entire sample will be consumed
I don't want a donut.
when we're done testing.
Next item.
Number 44, there are several swatches, and it's possible, we're hoping there may be some left when we complete our analysis. We haven't done anything, and we're not done.
Next item.
Number 45, we don't anticipate any being left. We have not tested it.
Next item.
Number 47, we have done PCR. We feel that they're, hopefully, based on what's there now, when we're done testing, that there'll be some left. Can't guarantee it, but looks promising.
48.
48. Probably will not be any left when we are completed. We have done PCR.
49.
49, we have done PCR and conventional and plan on RFLP. It's ready to send out.
50.
And by the way, on 49, we anticipate, that's one of the ones we anticipate there'll be enough left, hopefully, assuming everything goes well for the defense. Number 50, possibly. It's a little weaker than number 49, but there may be some left.
Number 51.
Number 51, we haven't done anything, and we don't anticipate any being left, though, when we are completed.
Number 52.
We've done PCR, and we feel that RFLP will consume the sample.
Is the next number 54?
Donald, save 5.
Yes.
Save
Number
it.
54, we have not done it. There's several little swatches, but we feel that RFLP will consume the sample.
Number 55.
Not tested. It's very, very small. Feel that there's not enough for RFLP, and that PCR and conventional, maybe, and polymarker, of course, is part of the PCR technique, will be all that'll be done on that one.
Number 56.
None left, but we feel RFLP will probably consume the sample. So that means RFLP and PCR.
Number 57.
That's 57 is a label found on a walkway, I believe. I made a separate note of this. It's difficult, again, because of the label, to say how strong the stain is and how much interference from the label. But assuming everything goes well, there may be enough left when we're done. We haven't done anything with it yet.
And 59 and 60 are corner samples.
That's correct.
Does that complete the blood that's been submitted to you to date? That you-
No, you
inventory?
also have number 72, which is a coroner sample.
What else?
Number 82, which is a coroner sample.
Anything else?
We have not, any of these were in the column that indicate split where I've written yes or no. That means we may do something with them. Number 84A, we've examined the nail scrapings, and we think that possibly, there won't be any sample left when we're done, but possibly we may be able to do PCR and 1 or 2 conventional tests. And 84B, these are the left and right hand nail scrapings.
Let me wake up, OJ.
Same thing.
There we go.
84C, the nail clippings. There won't be any left, but we may be able to do PCR and conventional. Number 84D are the right hand nail clippings, and there may be enough. It's even questionable. There may even be enough there to do RFLP, but we don't anticipate anything being left when we're done. Number 85A are some scrapings we received from the coroner that they scraped. We'd have to refer to their report. We believe we can do some PCR and conventional again, but don't anticipate enough being left. And 85B are some scrapings again. And anticipate PCR and possibly some conventional, and don't anticipate any being left over for the defense.
Does that complete the blood?
At this time,
Of the as to the origin of those hairs.
no, we have not. We don't have a hair.
We made it through part 2, guys. Yes. This is getting so good. I was very interested. Whoo, blood and hair. Marcia tried to put us out of our misery, but the judge or magistrate was not having it, which makes no sense to me, but hey, maybe things were different back then, right? I am sorry for the 2 people that just logged in right now, because it's over for today. But that's all right. You can just replay it. It was only like an hour long. Easy peasy. I know, Carrie. I could too. I could, but we can't because courts opened 11 minutes ago and I got to get to work. Thank you so much for coming out again today. Hi, Steve. I will see you all very soon in Judge Fleischer's courtroom. Behave, okay? Bye.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late at night, when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a wake, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a wake, there's no alarm. Streaming tales late into the night. Her laughter feels just right.